On behalf of the York County Bar Association, I would like to welcome all of you to this evening's Meet Your Judges. My name is Dean Dominic, and I'm the president of the York County Bar Association this year. Tonight we have with us several judges from the York County Court of Common Pleas. We have President Judge Richard Wren, Judge Penny Blackwell, Judge John Kennedy, Judge Stephen Linebaugh, Judge Michael Bortner, Judge Maria Musty Cook, and Judge Harry Ness. And we are pleased to have with us this evening as our moderator, Janelle Stelson, who's the news anchor for WGAL. Janelle has facilitated many local events and previously served as moderator for the Meet Your Judges event in Dauphin County. Janelle has more than 20 years of broadcast experience covering stories on a local, national, and international level. She is the recipient of several Associated Press awards for reporting. Recently, her legal reporting has included extensive coverage of the Roseboro homicide trial in Lancaster County in 2009. Please give a warm York County welcome to Janelle Stelson.
Thank you, everyone. I'm really impressed that York County turns out for an event like this, because let me tell you, I've been doing the Dauphin County event for about a decade now. I think they hold it every 2 years, and the first couple of years, there was never a crowd like this. So thank you very much for being here and recognizing the importance of actually getting out and meeting judges and being able to have a one-on-one relationship with the people you see up here. And we hope you don't see them any other way anytime soon. And when you said the nearly 20 years broadcasting experience, now I know why the young attorneys, the Young Lawyers Association is starting to actually really look young. They used to look my age, so they're looking very young to me now, too. Here's the way tonight is going to work. The judges whom you've been introduced to will give you a brief overview of what they do in their day-to-day business. And everybody should have been given a card like this, the index cards with a pencil. And if you have a question, please understand that the judges cannot get too specific. In other words, if you've been after your ex-wife for custody for 10 years and you still can't get to your 11-year-old son, that's not really the kind of thing they're going to deal with tonight. If you had a general custody issue or something like that, absolutely, we'll have a judge who deals with family court and can answer questions like that. But please understand why we can't get too specific tonight, though we would like to answer whatever your question is. So, at some point, if you want to fill those out while the judges are giving their overviews of what they do in their courtrooms, one of the young attorneys will come by and just sort of collect them at the end of the row and send them down. And then Steve McConnelly, who used to be in charge of the Bar Association, the York County Bar Association, okay. That's right, your old job. I mean, okay, he had your job before. That's right, okay. Well, I must say he's been great in terms of getting me here tonight, too, because I have to be badgered a little bit to show up anywhere. They don't let me out of my news cage very often. So good work getting me here, and it's a pleasure to be here tonight. I will also say, what's the situation with cell phones, everybody? Are they off? Anybody who has them? That's a great idea, and I would ask you to be understanding. I was born in Alaska, raised in Seattle. I have 3 little sisters. The only family I have in this area is the youngest sister. I was able to lure her here. She married an architect about 2 years ago. And I tell you this because they're going to have a baby any moment, and I'm the only family here for her. So I actually have my cell phone on. I will politely excuse myself, and Mr. McConnelly has agreed to step in and fill my role should that become necessary. So I apologize in advance if that's the case. And I was hoping, maybe they'll arrive a little later, but I was hoping we'd have a photographer here tonight, too, to showcase you all and the good work that you're doing. Because if you think your life is busy, try being a member of the overstressed, overtaxed judiciary as well. They're quite busy, so the fact that you're taking time to do this is very much appreciated, ladies and gentlemen of our judiciary. Let's go ahead and start our overview with your president judge, who has served for 4 years?
4 years.
4 years. Richard Wren.
Good evening. My name is Richard Wren. I'm President Judge of the Court of Common Pleas of York County. In addition to all the administrative responsibilities for running really the county's judicial system, for the past 2 years I've been doing civil trials, and mainly motions court for civil motions court. So that's my primary responsibility. I would say about 50% of my time is taken up with administering the judicial system. Everything from assigning cases to various judges, assigning judges to divisions, to overseeing personnel issues related to the judiciary's about 300 and some employees.
Good evening. My name is Penny Lee Blackwell, and presently I'm in the Orphans Court Division, as well as in charge of running the treatment courts. The treatment courts, for your information, are our drug treatment court, our mental health court, as well as we are starting a DUI court. That takes one day full-time and usually another half-day. The rest of my time is dealing with the state works, adoptions, and also dealing with persons who are alleged to be incapacitated. And that keeps me quite busy. So I will now pass the mic.
My name is John Kennedy. I'm currently assigned to the criminal division within the courts. That means my assignment involves handling everything from possession of a small amount of marijuana, which is punishable by a maximum of 30 days in jail, to a death penalty homicide. In addition, I'm working a pilot program with the State Board of Probation and Parole to handle the reentry of prisoners back into the community. Just about all of us, York County frankly has a history of judges working through the system to try to better the system, and one of the things I do is I chair the Pennsylvania Bar Association's Committee on Corrections, where we try to make improvements to the corrections system within the state.
Good evening, ladies and gentlemen. Thank you for being here this evening. I'm Stephen Linebaugh, and my current assignment on the Court of Common Pleas is to handle civil cases and all related civil matters. So we do civil jury trials and civil non-jury trials. Can be anything from medical negligence cases to injuries in traffic accidents, business law cases, products liability cases, any kind of civil matter. In addition, I've handled injunctions because they deal with the civil court. Over the period of time that I've been on the bench, I have now handled every type of case, from juvenile to family law, criminal, and now civil, with the exception of the Orphans Court that Judge blackwell now handles. But that was the area I practiced in when I was a lawyer for 25 years. So, but I haven't done that yet as a judge.
Thank you. My name is Mike Fortner. I began my tenure on the bench in 2003. For the first 6 years, I was in the family and juvenile division. Beginning of January this year, I accepted an assignment to adult criminal court. Whereas Judge Kennedy pointed out, I handle everything from taking guilty pleas, jury trials, suppression hearings, probation violation hearings, everything you might associate with the criminal courts. In addition to that, I've also retained the responsibilities for handling a juvenile drug court, which meets once a week.
Good evening, everyone. My name is Maria Musty-Cook, and I am assigned to the Family and Juvenile Division of the Court of Common Pleas. I currently handle protection from abuse matters, violations of protection from abuse orders, and custody matters in the family court. I'm also assigned juvenile dependency matters, which are those matters dealing with children who are placed outside the home in foster care or residential treatment facilities. I've just begun handling juvenile delinquency matters, which center around juveniles who have been accused of committing criminal offenses, and I run the JUMP Court, which is a juvenile court system for children who have mental health diagnoses and have also been accused of committed criminal offenses. I'm also currently supervising the family court judges.
Good evening, ladies and gentlemen. I, too, want to thank everybody for turning out. I'm the newest member of the bench. That's why they put me all the way down here in the end. I've been a judge for 2 months, 4 days. So at this point, I'm not real sure what I'm doing, but I do know what I'm assigned to. Judge Cook is my supervising judge to the extent that she's the administrative judge for the family court division, and I'm in the family court division. I handle the same types of cases she does. I handle the divorces. I handle divorce motions if people have issues of what we have to do Before we get to have a resolution of the divorce, they bring them before me. I handle protection from abuse, violations of protection from abuse, which are a criminal charge called an indirect criminal contempt. I handle support appeals, both general, when there's a big cattle call of everybody complaining about their order, special support appeals when they're complicated and they take longer than the 20 minutes usually allocated, child custody cases, and juvenile dependency cases as well.
Thank you very much. I must tell you, things run like clockwork here in York County. Normally, the judges in Dauphin County take at least an hour to tell us what they do. So that was great, and we'll be able to get more questions in that way. And this first one goes to the President Judge, Richard Wren, and it's kind of an interesting one. A lot of people may be wondering this. Why does it take so long to get my case resolved?
Whether or not it takes so long to get your case resolved really depends on what type of case it is. If it's a criminal case, they have to be resolved fairly promptly because of various constitutional requirements for a speedy trial. Family law cases are generally resolved fairly quickly because juvenile cases, if you're involved in something like that as a parent or a guardian, protection from abuse cases, support cases, all of those are heard fairly promptly because we put a high priority on trying to resolve family cases promptly. For instance, if you have a custody case and you file a custody complaint because you're not getting sufficient custody with a child, the first thing you do is see a conciliator in about 10 days after that complaint's filed to get a temporary order to stabilize the situation, and then your process goes from there. Typically, delays are not caused by the court system. We're pretty current in, I think, all of our caseloads at this point, including civil cases, certainly criminal cases. The civil case docket is mainly controlled by the attorneys involved in those cases. We literally could try a case next month if it was ready for trial. But the problem is there are so many things leading up to that that the court doesn't get involved in, that it's only after the attorneys tell us that the case is ready for trial that we will put a civil case on the docket. So really the length of time that your case is resolved depends on the type of case it is and whether or not the court is more active or the attorneys are more active in controlling the flow of that case.
Okay, thank you. We'd all like to welcome you. It's great to have you here. The next question, we're going to hit the other end of the table, and it's a two-pronged question that I think we'll divide up between Judge Cook and Judge Ness. Part one, Judge Cook, who makes the laws per county for custody, visitation, and deadbeat dads?
Well, the laws in all of those areas are actually statewide. There are some local policy rules that are devised by the court system, and that's all of us together. But for the most part, the state law governs how the case will proceed, what the guidelines are for setting support amounts, and so forth. We don't have any control over that part of it.
Okay. Judge Ness, why does the system feel deadbeat dads who do not pay support should have visitation?
You know, that's a question that I have gotten asked by clients over the 34 years that I was an attorney and by people who appear before me. But fundamentally, the ability to pay child support should have no reflection whatsoever on the way you feel about your child. There's any number of reasons that people don't pay support, can't pay support, and even those people who are just generally unwilling to pay support. That shouldn't affect their ability to continue to have and establish a relationship with their child. You're not buying affection out there, folks. What you're doing is paying to support your children, hopefully, and if you don't, you appear before either Judge Cook or myself, and we do what we can in the system to make sure, or to help you to find work so that you can meet your financial obligations. But if you want to be with your children and you want to love your children, you want to spend time, we urge people to do that, we support that, and we don't put a price tag on it.
And it's not limited to fathers either.
Good point. This is for Judge Kennedy. What word of advice would you have for someone who is appearing before you?
Well, number one, I'd suggest that they have a lawyer. which may sound funny, but we do get a number of litigants in the criminal side of the court who will come into court without an attorney. Many times it's because they just won't take responsibility for themselves to go to the public defender's office and apply for a public defender. Many times they would qualify for a lawyer. Other than that, I always appreciate it when people are honest with me in court, which frankly doesn't always happen. So other than being honest and having a lawyer, I don't know if there's anything else I can say.
You want to go into the T-shirts?
Well, yeah, your attire can sometimes affect things. I can recall when I was an attorney appearing in front of Judge Rawhauser. I was a prosecutor at the time, and a young man came in wearing gym shorts and a T-shirt, and Judge Rawhauser scolded him, told him to go home and change clothes. I was worried he wasn't coming back because everybody in the courtroom knew he was going to jail for 5 years, and I thought, gee, he may not come back. But we generally will look beyond that now, although every now and then someone will come in, for instance, for a DUI sentencing, and they'll have a Jack Daniels T-shirt on. I can recall the case. I wasn't present in the courtroom, but the gentleman was on trial for burglarizing a tuxedo store, and he came in wearing tuxedo pants. So you want to be a little careful as to what you wear to the courtroom.
And mindful about why you're there. Okay, this next one is for Judge Bortner. What inspired you to pursue law as a vocation?
Wow.
Takes you back.
It does take me back. A couple of things. One, I remember the first book that I really can honestly say in high school I was assigned to read that I couldn't put down. It was To Kill a Mockingbird. So that was a book that I read that was important to me. I had some very good teachers in school, and had some projects where I was asked to pick a career. I didn't know any lawyers. Nobody in my family was a lawyer. My father worked at the P.H. Gladfelder Company, so I didn't know lawyers firsthand. I always thought that lawyers helped people. That's something that I wanted to do, and I made the decision to go to law school. I practiced in the district attorney's office, and sort of my career took a turn into some other aspects of public service, but eventually brought me back to the bench. But I think it's just it's a profession that I felt is one that where you can really make a difference in people's lives, and that's what I think attracted me to it as much as anything.
Great, thank you very much. This next question is for Judge Linebaugh. Do you have a pet project that you would like the community to support?
Actually, I do, but it's not a project that I'm presently working on, and that project I'd like the community to support would be the drug treatment court program in York County, the Adult Drug Treatment Court. Just a little bit of a background, York County Adult Drug Treatment Court was the second drug treatment court in the Commonwealth of Pennsylvania. We started in October of 1997. There was a program in Philadelphia that began about 5 or 6 months before that. And one of the people who is not only most responsible for our program, the person who is most responsible for our drug treatment court is Judge Kennedy. Judge Kennedy was very involved, and he is well known throughout the Commonwealth of Pennsylvania and beyond with his work in drug treatment court. The reason I'm interested in drug treatment court, the reason why I want to see the community participate and to support it is because it works. People that are, and I should tell you, we don't handpick the people who go in drug treatment court because we think they're going to be successful. When there is an opening, the next person in line who happens to qualify, and it's our drug treatment court doesn't take violent offenders, but we take people who commit crimes, sometimes serious crimes and lots of crimes, and they commit those crimes not because they're criminals, but because they have a drug addiction. They have an illness. And those people, and I don't care if you put them in jail for 5 years, if you put a drug addict or an alcoholic for that matter, into jail for 5 years. When they come out 5 years later, they're still going to be an alcoholic and they're still going to be a drug addict. We've done nothing to attack the problem. We take in drug treatment court everyone across the board. I've had people in the drug treatment court, and Judge Blackwell is now running it. Judge Kennedy did a great job with it for many years in York County. But we've had people in there who have been drug addicted since they were 11 or 12 years old who have never held a job. They've never had a source of income. They just make money, enough money to do their drugs and to do more drugs. And we've gone from everywhere from that up to physicians, leading surgeon in the community and leading other physicians that have been in the community, nurses, pharmacists, across the board, mortgage brokers, people that have never had jobs. And they get jobs. They go through this program and they do a number of things. Number one, they go without drugs. They become clean because of treatment. And they do that for the first time in their lives. They've never been clean in their life, or they've never been clean for any serious amount of time. The second thing they do is that they are in treatment, so they start to understand their addiction. They understand what they're doing. It's not an easy program for them. The people in this program frequently are looking at not serious jail time, but they do serious time in drug treatment court. They're in court every week. Once or twice or 3 times or more, they're meeting with probation officers. They're all required to get employment. When they graduate from the program, if they've never worked a day in their life, they're in court. They're in employable situations. They're working. They're contributing to the community, and they're working full time. They're paying taxes, and they're not committing crimes, and they're not in jail. All of those things save money, and the real test of what we do in drug treatment court is that the people who are successfully graduating from drug treatment court do not reoffend. They not only do not reoffend, but they go out in the community and they work with other people that are in the same situation. Almost every person to the individual that's finished drug treatment court is back in there working, and they're not in jail. They're not committing crimes. They're trying to divert other people from committing crimes. And that's something that we need to do in the community. When I first became a judge, and Judge Kennedy approached me and said he wants to, I really think you ought to get involved with this. And I said, I don't do that. I'm a judge. I want to be in a courtroom doing judging. I'm not a social worker. And I'm not going to be doing social work. And he wouldn't leave me alone. He kept bugging me about it, and he finally convinced me to go and do some training and to get involved with it. And I became a believer. I became a believer because it works. And so I would encourage each one of you, every one of us knows someone or has someone in our family who is addicted to drugs or alcohol, and we know that it impacts the entire community. Please do what you can to go out there and encourage people in the community to support our treatment programs, our drug treatment program, our DUI program, our mental health program, because, ladies and gentlemen, it works. It keeps people out of the criminal justice system, and maybe we won't need as many judges in the future. We won't have to continue to add judges to our overcrowded dockets that we have.
Thank you very much. This next question is for Judge Blackwell. Well, sociological bent here. Do you feel 2 parents can do a better job than 1?
It depends on the parent. And you may laugh at that, but if the parent is not engaged in raising a child and truly committing and having that child in the community, it's a failure. And the old adage of it takes a village to raise a child is very, very true. And if you have one parent who's effective and one isn't, hopefully the effective parent will be good. But I've seen single family or single parent raise wonderful children. I've seen, because I did custody for 9.5 years, I did custody and dependency. And every time I thought I'd seen it, something would come into my courtroom and I would go, oh no, here we go again. And I cannot stress enough, it's the quality of the parent and it's the interest of the parent in the child. It does not matter whether it's 1, 2, or grandparents or foster parents. If that child is involved with that parent, that child has a very, very good opportunity to be successful.
Thank you. Judge Wren, how has technology changed your job?
Well, it's good you asked that question today because Information Services has now taken my computer and upgraded it so that I've lost all of my emails over the past, 6 weeks. But now, in all seriousness, it has helped us become more efficient. We're scheduling now using electronic calendars. We're using email more, so it's saving paper. We don't have to do fax machines and copying of things like our judicial agendas. Memos are going back and forth quicker. It's really made us more efficient in the judiciary, and that's very important this year because of our extremely tight budgets that we have. We've traditionally been understaffed in court administration, and frankly, I see Bob Chuck back there, our court administrator, in the audience. I'm not sure how he keeps his office running and does everything we ask him to do, and probably wouldn't be able to do it without technology. On the other hand, it does create problems for us. One of the things that the judiciary got criticized for when we moved into the new Judicial Center was the banning of the use of cell phones in the Judicial Center. If any of you have come to the Judicial Center on George Street, you know that you can't bring your cell phone in. And the reason is because of prohibition of recording things, taking photographs. We have issues with jurors tweeting other jurors or outside people and asking for advice. There's not a judicial conference that goes by in the state where I'm not approached by one of my other colleagues in another county saying, Judge, how do you handle the issue of cell phones in your Judicial Center? So it's very easy. We don't have them. And that eliminates a lot of the problems associated with that. So like everything else, it's a two-edged sword. It's made us more efficient. It's also made us more aware of some of the abuses that can take place when technology is present.
Thank you very much. Judge Cook, could presumptive equal custody lessen the caseload of custody trials over time?
I don't believe necessarily that it will. I think in custody cases, every case is an individual case that has to be looked at for the quality of parenting that's going on. Each parent comes in, presents their case, and we have to look at it on a case-by-case basis. If that legislation is adopted, I don't believe that it will necessarily lessen the caseload. It may require us to look at cases a little bit differently, but I believe, again, we have to remember that each child is different. Each child is supposed to be given a standard of looking at their best interest and only their best interest, and so I don't believe that that will really change the caseload.
Okay. Judge Bortner, what God are we swearing to in the taking of the oath?
Well, the oath is administered by the clerk, and you're taking an oath to whatever you believe in. Actually, you can testify and without actually taking an oath that you believe in God. So that rarely happens. I don't think it's happened in my courtroom, but it is possible to testify without actually taking the oath that you believe in a divine being. But otherwise, the oath is taken to whatever you believe in personally.
May I answer that? We looked at that issue about 5 years ago and actually talked to our legislators about it because, believe it or not, the form of the oath that we have to use for our jurors to swear them in, for witnesses, is actually prescribed by the legislature. And the words that are read, if any of you have been in court, by the prothonotary or clerk giving the oath, are those words that are prescribed by the legislature. We have tried to make it neutral. We've tried to institute programs where we ask a witness, would you prefer to swear or affirm? And the response we usually get is, what do you mean? So we sort of abandoned that because then it puts the witness in a rather uncomfortable position many times. So now we sort of give them a hybrid oath, if you will, one that they can either choose to swear or affirm, and hope that that doesn't alienate any of the witnesses. But if you have any difficulties with the oath, don't talk to us about it. Talk to the legislators. We have, and haven't gotten a very sympathetic response.
What if somebody swore to God and then later could it be thrown out of court if they said, I don't believe in God?
Not likely, because it's not who you're swearing to, it's the solemnity of the moment, so that whatever words you say to the witness impresses upon them their responsibility to tell the truth.
Okay, thank you. Judge Kennedy, why don't all cases require a jury? Criminal, civil, traffic, they say.
Well, again, that's prescribed by the law. That's in effect, essentially, if your imprisonment time is not going to be greater than 6 months, you do not have the automatic right to a jury trial. And then, in addition, an individual has the right. It used to be a complete right, where an individual could waive the right to a jury trial and be tried by a judge. With some changes in the law now, the Commonwealth, or the state, has the right to object to that, and the state can insist on a jury trial. But essentially, those matters are prescribed by law that, again, we don't control.
Okay. Judge Wren, when a decision is overruled by a higher court, is there any repercussion on the judge who was overruled?
Usually not, unless there's something really egregious that happened in the lower court. But, I mean, frequently, as the case that I was recently involved in, there are novel issues of law that two judges, even on the appellate courts, can see cases different ways. That's why you have majority opinions and dissenting opinions, because the justices on the Supreme or judges on the Superior Court or Commonwealth Court see the case differently. And it's no different than the case from the lower court to the appellate court. The lower court judge makes his call, and if the appellate court disagrees, then the lower court judge gets reversed. But try not to take it personally. You take it and you move on.
If you get reversed a lot, do people sort of start looking at you in a different light?
Well, no, because really it's not an indication of the quality of the justice that's being administered. Percentage-wise, very few cases are reversed. And that just means that judge either has more difficult cases or unusual cases that get up to the appellate courts.
Thank you. This is for Judge Bortner. Do jurors have the power to judge the law as well as the facts? If so, why don't the judges make this known? If not, why not?
Well, when you're conducting a jury trial, you tell the jury that they are the judge of the facts, and they alone are the judge of the facts. You tell them that if the attorneys misstate the facts, or even if you as the judge mistake the facts, they're to disregard that because they, as I said, are the sole trier of facts and the determined credibility of witnesses. At the same time, you tell them that they are not the judge of the law, and they have to accept the law as you give it to them. Now, having said that, when jurors go back to retire, they can come back with a verdict, and they don't give any reasons. So you can speculate on whether they didn't like the law, had some sympathy for a defendant, thought the law was unfair. In the case of a jury trial, you'll never know. But the law is that jurors decide the facts, the judge decides the law, and instructs the jurors on the law that they're to apply to the facts of that case.
Okay.
If I can add just a little, I know that's a hot topic. I picked up the materials that were out front and I read them. What I always tell the jury when I'm explaining this, and frankly, I understand the position of the folks that believe that the jurors should have the right to essentially nullify whatever law they hear. I understand that position, and it's a worthwhile debate. But as judges, we're required to follow the law as it is in Pennsylvania. And what I tell the jurors is that it's kind of like if you're at a football game or a lacrosse game, and you're out there on the field. I use an example where my son was playing lacrosse, and they had special rules because it was a tournament. And the referees out on the field started to blow the whistle when the kids were following the rules for the tournament because the referee was following the league rules. And our coach had to say, well, stop. And he went in and talked to the referee and said, what rules are you going to be playing by? I need to know so I can tell my players how they can play. When we're conducting a trial, the lawyers need to know what law the jury's going to apply, or they don't know how to argue their case to the jury. And if they have to guess what law the jury's going to apply, their job is impossible, not to mention very difficult. I also look at, what has happened in this country when the jurors have disregarded the law. There can be situations, William Penn's trial, of course, is a classic, where the jurors did the right thing. But look at the situations we had, back in the 60s in the South, where if a white man went on trial for a crime against a black person, they were getting acquitted. And it was because the jury just wanted to ignore the law. They didn't want to treat those two people as equal. I don't want to see us get to a system like that either. There can be times when I think as a citizen, it may be your responsibility to take part in civil disobedience, as we've seen occasions in this country. But in general, I think we have to uphold the law. And if you want to change the law, again, if the jury isn't following the law and the lawyers want the law changed, or even if the judge wants the law changed, that law can't be changed in Pennsylvania unless it gets appealed. And then as a judge, I can say, this is what the law is, this is what I think the law should be. I hope you appellate courts will agree with me and change the law, which is what the attorneys do when they appeal, and that's how we get the change of law in this country and in Pennsylvania currently. But again, if the appellate courts don't know what law the jury applied, because the jury says we're going to apply whatever law we think is right, regardless of what the judge says, we have a very inconsistent system of justice, and we have a system where we really can't get the law changed. So I'll just add that.
Just one other point on that. I mean, we are a nation of laws, not men. And it's not our job in courts to make the law. This is a discussion that comes up all the time. We have a legislature. We elect legislators to go to Harrisburg or to Washington, in the case of federal laws, and make the law. That's not the job of the courts or the juries to make the law. We have a process for that.
This was a good segue, Judge Kennedy. You picked it up last time, and this next question is actually for you. Is it the judge's duty to protect the defendant's rights?
I would say it's our duty to apply the law. There are times when that means we are protecting the defendant's rights. I had a trial within the past year where the defense lawyer was clearly incompetent and put his client on the witness stand without explaining to the client what the law was. And essentially the client took the witness stand and confessed to the crime. And when his testimony was over, I sent the jury out to the jury room, and I said to the lawyer, I said, did you inform your client that through his testimony he was going to confess to the crime? What it was a possession with intent to deliver cocaine charge. The law in Pennsylvania is if you buy cocaine with the intent of sharing it with your friends, you possess it with the intent to deliver, because delivery of cocaine in Pennsylvania does not require a sale. Unfortunately, the defense lawyer thought that the delivery of cocaine in Pennsylvania required a sale. So he put his client on the stand who said, I wasn't going to sell the cocaine, I was going to share it with my friends. So his client confessed to the crime. And at that point, I didn't have much choice but to declare a mistrial because the defendant's attorney was incompetent. And in this country, you have the right to competent counsel. And so we gave the man a new trial. There, I guess you could say I was protecting the defendant's rights, but my job is really to do justice. Sometimes that means that you have to protect the defendant's rights. There have been some very rare occasions where I've also asked questions of a witness when the prosecutor perhaps wasn't competent enough to bring out the appropriate facts. I can recall a case where there was an expert in on DNA, and when the prosecutor finished her examination of the expert witness, I had no idea what the expert witness said. I didn't understand anything he said. And I thought, I've heard DNA experts testify before. If I don't understand what this witness said, I'm sure the jury doesn't. And I knew what the witness had to say was important for the case. So I actually asked the witness some questions so that the jury could have that evidence before them, because it was necessary for a just resolution of the case. So there are occasions where the judge has to step in. My personal preference, and again, it's a matter of personal preference among the judges, I do my best not to ask questions of witnesses, because I feel it's the lawyer's responsibility to try the cases, and I don't want to ask questions of a witness unless it's absolutely necessary. But there are times, out of reasons of justice, that we need to step in and do something, whether it's to make certain that the correct facts get to the case or because somebody's rights have been violated.
Or to make sure the jury understands.
And to make certain the jury understands.
Okay, Judge Blackwell, what is the percentage of cases where it is decided the children should remain in the home instead of removal from the home? And conversely, what is the percentage of cases where the child has been removed from the home is returned to their family?
I might ask the dependency judges or delinquency judges to address that, because really what I'm dealing with are adoption cases at this point, and I don't really have the numbers on the or the stats that you're asking for.
That's great. Judge Cook, if you'd like to.
Sure, I'll try. I don't know that I can give you exact percentages. I can tell you that there's been a very strong move afoot, which was generated by Supreme Court Justice Max Baer, to reduce the number of children in foster care. And in York County, we have gone in the last year and a half from 550 children in foster care to 274 children as of about 2 weeks ago. So we have greatly reduced the number of children in foster care. What that means is we have to take a really hard and fast look when the cases come in to make sure primarily that the child is safe wherever he or she is. If that means that we can do that by keeping the child in the home and providing services in the home, that's what we're looking to see happen. If that means that we need to remove the child for some period of time, that's what we do. We work towards getting the child reunified in most cases. Sometimes that happens quickly, sometimes it doesn't happen so quickly, but I can't give you hard and fast percentages because it's a very fluid situation and it changes from year to year.
Okay, thank you.
If I could just add to that.
Sure.
Coming out of dependency court, contrary to what people might think, we're very slow to take children out of their families in the first place. Many times when Children's Services gets involved, they work with the families in their home without having to remove the children. We have to actually, as judges, make a finding that remaining in the home would be contrary to the children's welfare. And if you can't make that finding, then they remain in their home. We also set a goal when a child is removed from home, and in almost every case, that initial goal is to return home. So the effort from Children's Services is to provide parents with the assistance and the services necessary to have their child to return home. Also, by law, every case has to be reviewed every 6 months. So it's not as though we place children in foster care, which I think had historically maybe been the case, and there was this idea of foster care drift where kids just got lost in the system. We as judges have to review a case where a child's been removed from a family every 6 months and determine whether that initial goal of return home continues to be the right goal, whether we need to set a different goal.
And we've actually changed in York County. We are part of a permanency initiative, again, under Justice Baer's direction, so that we are reviewing cases at least every 90 days. It doesn't go a full 6 months, to make sure that those services are in place and the parents are working towards their goals.
Okay, the next question is for Judge Ness. Can I send a letter to a judge and tell the judge some things that did not come out at my trial?
Well, people sure do. And of course, you can. I guess the real question is, what would the judge's response be? You know, we have a duty as judges to be fair, and being fair requires that we not allow any litigant to get involved in something called ex parte communication with the court. Both sides have to be involved. It's not fair for one side to get a direct pitch to the judge and the other side not to even be aware of it. So what we routinely do, and we have a form letter, and all the judges have the same form letter, that if we receive a communication from a litigant indicating that he believes that his position wasn't advanced as ardently as they thought it should be, and that information wasn't developed, and they try to add that information to us, I don't see them. They are reviewed by my staff or by my administrative assistant or by my law clerk. They would determine that it's an ex parte communication. The form letter goes out, and I'm not even sure we keep a copy of it. I think we return the letter and say, please, this is inappropriate for you to correspond with the court. Contact your attorney. If you're a self-represented individual, as they're now called, you have the rights and remedies to file requests for modification, whatever it may be. But no, it is in the end not something we will probably even see, but we'll know about it.
Okay. Judge Wren, there are at least 2 Judicial Center court tour leaders present tonight. Excuse me. As judges, do you have any preferences how we handle groups of 10 to 20 persons? Any are groups of high school students?
Quietly, if you would, please. No, and I don't think any judge here would be opposed to having the students come into the courtroom. It would be nice to tell the court administrator so that they're prepared. But I don't think anyone would have any objections if the students filed quietly into a courtroom watching a matter that was already in progress. The only exception are any closed juvenile hearings. I guess any mental health or adoption hearings are closed also. But any other case, for instance, this week we're having civil and criminal jury trials. Again, a group could come in quietly, sit in the courtroom. We usually have plenty of space. But again, check with court administration if you know you're going to have a big group. Perhaps court administration could alert the judges that may be occurring, so there's no surprise in the courtroom. But you know, groups of 10 or more, just as welcome as groups of 1 or 2.
Okay. Judge Linebaugh, why is verbal, this is with regard to civil suits, why is verbal argument frowned upon in a non-jury trial?
I think I want an easier answer or question.
Excuse me.
I'm really not sure. Yeah, I'm not really sure that I understand that. I think that what the question might be asking is why is oral argument by the attorneys frowned upon? And I think the answer to that is it's not really frowned upon, but when you get to that point of the trial and the trial is over, and that's usually when the lawyers make their closing statement, I think that you have to keep in mind as a litigant that in civil trials there are frequently motions that have been decided during the leading up to the trial, and those motions have briefs that have been filed and have been argued. There is a pretrial memorandum that has been filed, and this is true whether it's a civil trial or not, a jury trial or non-jury trial, and then there's a trial brief that is filed. All those documents are reviewed by the judge. The legal issues that are raised in those briefs and those memorandum and the case law that is cited or the statutory law that is cited, the judge reviews. I have a law clerk that when we talk about those things, we generally have memos going back and forth between us, and there will be research by another person that's been done. So when you get to the end of the trial and you get to the end of the proceeding of this, and let's say it's a non-jury trial, but it could be a jury trial, but in a non-jury setting, quite frankly, everything that needs to be said has been said, and the lawyers they produce proposed findings of fact. You see, we don't have in television. Frequently, there's these great events that happen sometime during the television show where somebody blurts something out no one's heard it before. That does not happen in our civil jury system in the real world. We know there are no surprises. Everything that can be produced has been produced, probably 2 or 3 times. Every argument that can be made has been made. 2 or 3 times. So it's maybe for the benefit of the client, you may want to hear your lawyer stand up and really repeat the same things that have been argued to the judge over and over again, but the facts, there are no new facts. We know what the facts are. I have trial books or a series of trial books or a disc with all the evidence on there. I've had all that months before the trial. So there's nothing new under the sun when you get to the trial. When you get to the trial, it's all over and done with. And that's why frequently I will offer to the attorneys, or I generally say, you've covered these points in your various trial memorandums, trial briefs that you've filed. Do you have anything additional that you want to say, or a summary? And sometimes the lawyers will say yes, but they're not telling me anything new. So that's the only reason why it may appear to a litigant that the issue, that your arguments are being discouraged. But just getting that question is something that I intend to now make sure that at the end of a non-jury trial that the litigants do understand that's the circumstance that we're in, and ask their counsel if they want to do that. I mean, I'm assuming that the lawyers have already explained to them we won't make a closing argument because we've done this. The judge has all our information. But whoever asked that question, a very good point, and I assure you that from now on at the conclusion of the trial, I will give that explanation and give the lawyers an opportunity. So whoever asked the question, thank you for asking.
So you're saying NBC's Law and Order takes a little artistic license? There's not always a big surprise at the end that solves everything?
I've never seen that show, but since it's on NBC, I'm assuming
Pretend
it's very
you see
good.
it, Judge. That's right. Thank you. All right. This next question is for Judge Blackwell. Do you believe that a constitutional right exists with the court to write and create rules of court that would subvert legislatively created laws and statutes? Need a repeat? Are you good?
Please.
Okay. Some of them are harder than others. Do you believe that a constitutional right exists with the court to write and create rules of court that would subvert legislative created laws and statutes?
If I understand the question, we have rules of court. They must be consistent with the statewide rules. We cannot, for example, create a rule that would undermine whatever the statute is or whatever our rules of conduct are. So I don't know if that answers the question, but it really, we are not permitted to subvert the laws of the Commonwealth, because really we, at that point, in my estimation, we would be undercutting those laws that have been enacted. However, having said that, if someone comes in front of us to challenge, say, a very particular aspect, that is something that both sides would have the opportunity to argue to the court that there may be a flaw in the law, or there may be a sort of a lack of clarity. And those are the matters that we then address. But for enacting rules of court, and maybe the President Judge can add to this, it is up to us to follow the path of the law.
Even on a 3 strikes you're out, if those 3 strikes are so absolutely minor in your mind and you understand why they were committed, let's say I got laid off from Falsgraf and I just needed to feed my 5 kids, stole bread 3 times. 3 strikes, I'm going to jail forever. Now they don't have a parent, and we don't have money, and we don't have bread. I mean, to take it down to its lowest common denominator.
Well, they wouldn't be felonies.
No, has to be a felony.
Has to be a
Was a lot of bread.
Well,
By bread, I meant green bread. Yeah.
But with that said, you'll find very few judges in the state who favor mandatory sentencing laws, and one reason Pennsylvania's building 4 new prisons with a cost of $250 million, and one reason we're paying other states to house 2,000 to 3,000 of our inmates is because we have mandatory sentencing laws. And I frequently will state on the record the district attorney will request that a mandatory sentence be imposed. And I will frequently state on the record, I am imposing this mandatory sentence because I am required by law to do so. Were it not for the mandatory sentence in this case, I would sentence the defendant to far less than what this mandatory sentence is requiring. So there are situations that, if the legislature said you steal a loaf of bread 3 times and you go to jail for 25 years, if they pass that law, as judges, we are bound to follow that law until it gets declared unconstitutional by a court higher than us, or until the legislature reverses itself. So with that
But you
said,
at least go on record
we-
as
we-
not
we-
loving it.
we can go on record and say we don't agree with this law, but we are bound. When we were all elected, we took an oath to uphold the Constitution and to follow the laws of Pennsylvania, and we are required to do that. So we must follow the law, even if we don't agree with it.
I don't know if the question was getting at this. It gets a little tricky because the Constitution created a unified court system, and it gave the Supreme Court exclusive authority in certain areas. So there have been situations where the legislature has actually passed statutes that the Supreme Court felt invaded what is their exclusive province, and they have found those laws to be unconstitutional. So there is this, the Constitution gives the legislature certain authority, gives the courts certain authority, and there have been times where they've conflicted. I don't know if that's what the questioner was getting at or not.
Not sure
Yeah, the
either.
question
not
is-
being asked.
The question is interesting on a lot of different levels. You start with Judge Kennedy's observation about mandatory sentences and that judges are required to uphold those. Our Chief Justice, Justice Castile, and Justice Aiken from the Pennsylvania Supreme Court just testified before the Pennsylvania legislature opposing mandatory sentences, saying, look, too many people are in jail because of status, drug offenses, because of mandatory sentences. We don't have the right people in prison. And those are 2 former district attorneys coming out saying, you've got it wrong with the mandatory sentences. But that has to deal with what the law is that the legislature passes. The question, as I understood it, can the court make rules that contradict certain laws? We can make local rules that are consistent with the statewide rules that the Supreme Court promulgates. That's our prerogative in certain areas that we're permitted to do that. The Supreme Court sets rules of procedure for the courts throughout the state, and we all have to follow those. Occasionally, those rules will conflict with statutes enacted by the Pennsylvania legislature. And if that's the case, then the Supreme Court will declare those rules or the statutes suspended because of the separation of powers doctrine. The Supreme Court gets the opportunity, and the judiciary controls its practice and procedure before the courts. That's not something the legislature is permitted to tread into. And if they do that, and the Supreme Court says, no, you've gone too far, then they can, by rulemaking authority, suspend acts of legislature to a certain degree. But again, now you're getting into the constitutional debate between the separation of powers between the judiciary and the legislature. Good question.
Judge Ness, having only been on the bench, I think you said 2 months and some change. Not sure that you'll be able to do this, but this is directed toward you. If, as a citizen, you want to get involved in changing the laws in family court. So in other words, if somebody out here wants to get involved in changing the laws in family courts, how do they go about it?
And I guess family court is such a large umbrella that it's a difficult question for me to perceive an answer to, because we're talking about matters of juvenile dependency, we're talking about matters of divorce, we're talking about matters of child custody, child support, protection from abuse. So the overall umbrella is difficult for me to be able to answer the question in what you should do specifically with respect to changing laws. And the courts and the bench has pointed out that there's a clear separation of powers here. We are the judiciary. We don't make the laws. It's our job to interpret, to understand, and to enforce the laws. It's the job of the legislature to make changes in the law. So to the extent that you want to involve yourself in changing the law, you need to invest yourself in the process. you need to get out and vote. You need to deal directly with your representatives in both houses in Pennsylvania. You need to correspond with them. You need to understand what the laws are that you need to change or you think need to be changed or you think that are being dealt with inappropriately. Become what all of you appear to me to be, and that's responsible citizens. It's nice to see this number of people turn out. But these are the kinds of things that you have to turn out to. You have to turn out to public forums. You have to turn out and meet your representatives and talk to them, because that's the only way, for the most part, it's going to change. You will not be able to address any of us individually and ask us to make changes, and although we meet periodically to discuss trends in the law to see how we can respond to it, your best bet is in the ballot box.
And we don't want to get specific, but that's where some of the best attorneys are born, people who have a cause and really go after it. So if you're not past the age that you want to go to law school, that might be something you want to visit too. This next one is for Judge Cook. It's a little bit long, so bear with me. With the social stigma based on so many, in quotes, deadbeat dads, what protocols or parameters have been established to protect the fathers who value and wish to continue the relationship with their children? Point blank, why do good fathers have to defend themselves against the stereotype and what seems to be such a biased system that almost overcompensates for what women were shorted on before? If communication between parties and judges are not supposed to happen, why are continuances allowed to happen to make sure that a particular judge oversees the case?
Well, that's a lot of questions in one. Let me see if I can pick it apart a bit.
If you need to hear it again, let me know too.
Well, first of all, custody and support are two separate and distinct issues. They are treated very separately in our court system. If you have an issue with seeing your children, you get involved in a custody dispute. You file your complaint or your petition for modification, and you get your day in court fairly quickly in York County. You have your conciliation within 10 days to 2 weeks. You have a pretrial conference after that. You get to go to mediation and try to resolve it without court intervention. I think, in my experience on the bench and as an attorney before the bench when I was a conciliator as well, I don't believe that there's any perceived bias at this point in time in York County against fathers and for mothers. I think we tend to look at cases, again, best interest of the child. You can have a good mother and a bad mother. You can have a good father and a bad father. In support cases, if you're not paying, you get called into contempt court. I spent 4 years doing contempt court. You have every opportunity to explain what you have been doing and haven't been doing to support your children. You have every opportunity to get involved with job searching, going to the father's workshop. They will assist you in finding employment. There are all kinds of steps you can take. If you come into court and you've done nothing, then you can expect that you will have to suffer the consequences. But even those consequences in York County give you some leeway. We don't throw you in jail the first time you come into contempt court unless it's something really, really egregious. You have an opportunity to participate in the father's workshop. You have an opportunity to go out and prove to us that you're job searching, that you're doing everything you can to support your children, and that's whether you're a father or a mother. There's an obligation that goes both ways. So I don't know if I hear the question as it must be coming from a father that perceives the system to be stacked up against him, but I don't believe in this day and age that it remains so.
If I can add to that, you know, there's been a change both by our Supreme Court and by our legislature to make the focus of contempt court. And while it may be called contempt and while we may make a finding that you are in contempt, our focus is not to punish. That's the focus of other parts of the justice system. Our focus is, as judges, and we're admonished to do what we can do to try to help the individual who is unable to pay his support or her support, who is unable to find a job. Judge Cook has made reference to the Father's Workshop. Those people are here tonight. It's a great program that allows people to pay through them, to monitor their payments, to find jobs. They deal specifically with people who are challenged in the job market, and that is to say, people that got significant criminal histories. It's hard to find a job under those circumstances. But we understand those difficulties, and our job is to help. And I know that there may be a perception, and historically there might have been a situation where we were just punishing people. We just don't do it. We don't want to do it. Second thing I want to make response to is that we don't do judge shopping. It's not going to happen. The suggestion that people will continue a case in the hopes that they'll appear before another judge just doesn't happen, other than that a judge may leave the bench. But we are mindful of our own schedules. We do what we can to accommodate, and we do grant continuances to people when they're justified. But Judge Cook was before call of the list this morning where 40 or 50 custody cases came in. 5 of those were scheduled before me, but 3 of them asked for continuances, and she said, go see Judge Ness. So that doesn't happen, and you don't get the judge shop.
Okay.
That was actually my question. I didn't mean to be so vague with it. When you have a father that's gainfully employed, educated, wants to do every single thing with his children that he can, has evidence that can prove what he's done in the past, why does the court system allow the whole process to continue when there's children that say we want to be with mom as much as dad, or vice versa, and there is no situation occurring other than somebody manipulating and creating a situation? I think that's more what I was trying to get to.
And that's still broad enough. Is that something you'd like to take? Or
I'm feeling like we're getting a little case specific here, but
that actually could have to do with almost anybody. You're not being...
We have a process in custody court, as I keep saying, and we've all been saying. You file your complaint, you get your conciliation, you move your case to mediation, you move your case to a pretrial conference, you go to trial. All of those things are lined up. They only get delayed when the attorney or the party who's unrepresented comes to the court and says, I need more time to do this, I didn't finish my workshop, I need to go to mediation, I need more time, we're trying to settle it. If you want your case to go to trial in York County, your case will go to trial in York County.
Great.
So either party.
Either party can push it through if you want your case to be tried.
We have no backlog in our custody caseload. We have no backlog in our criminal caseload. We have no backlog in our civil trial caseload. We're a little bit scheduling out a little bit further than we're comfortable with for support appeals. We have no backlog in actually hearing the first round of support hearings.
Good.
And we're down 2 judges at this point.
You're good, sir? Okay, sure. It's a great forum, isn't it, that you can get this kind of information? That's pretty cool. The Supreme Court gets together for lunch pretty much every day, as many of the members as can. How often do you all see each other?
At least weekly.
Is it a lunch, dinner?
Lunch on
Really?
Wednesdays.
Is that good? You guys discuss calendars or?
We have a judicial conference that includes all the judges the first Wednesday of each month. Second Wednesday of each month, all the judges primarily involved in criminal cases meet. Any other judges invited to attend, but the meeting is specifically to address criminal issues. Third Wednesday of each month, civil and family judges meet. And then the last Wednesday of each month, I meet with our judicial department heads, which would be probation, domestic relations, adult and juvenile probation.
This is for Judge Kennedy. On what grounds are duly elected constables denied their office because of a past criminal record, while permitting a convicted felon to take his seat as a judge in the York courthouse?
Well, let's correct the record. I'm not a convicted felon.
I didn't realize that this was pointed at you.
That was specific to me. Somebody's wrong.
Okay. Would you prefer not to take this question, Judge Kennedy?
To be honest with you, I don't know exactly what the rules are as it relates to constables. And believe it or not, as judges, we get questions a lot of times where we don't know the law off the top of our head because there is so much law to know. The question was just asked really as one of election law. And if I got that question in my I assume it would come to me by way of petition to remove a constable from office who had a prior criminal conviction or something of that nature. And if I got a petition such as that, the first thing I'd do would be wait for an answer from the opposing party to see what their answer to the petition was, and then see whether each side filed briefs. I would look at the law as the parties felt it was, and then I would do my own research to see if the law that the parties submitted was the correct law, and then I would try to figure out what the correct law was, and then I would make my decision based on the law and the facts. I think Judge Ness corrected the record on the second part of the question.
Okay, Judge Ness, do you want to take that any further, or you're pleased with?
No, I just, I kind of feel like I'm back on my campaign trail again.
I'm sorry, I didn't have knowledge of
That was an issue for a
this.
year and a half, and apparently 30,000 voters disagreed with that as being a significant issue. But again, whoever decided to pose that question, check your facts before you ask something publicly that you have no idea what you're talking about.
Okay, thank you. This one's a little easier. Judge Wren, is the basis of law fixed, or does its core evolve from legal decisions?
Both. We start out with a framework from the legislature that, there are certain laws, obviously, the legislature passed that we have to interpret, or if you will. However, that process of interpretation involves case law and decisional authority by our appellate courts, which we as trial courts are bound to follow. So while you may start out with a framework of laws, that framework is filled in with case law, judicial decision, which is the traditional common law, English common law that's been handed down to us by case decision. So, it's evolving. It's constantly evolving, which is why we constantly get these books every week that we have to read all the time to consider what our appellate courts are now saying about a particular issue.
Okay. How many people stayed up late last night watching the Oscars? Anybody? Not so many. Wow, I thought everybody watched the Oscars. I was just going to say we're going to try to wrap things up. People maybe it's warm in here, getting a little sleepy because they were up late. But we are coming to the end of our questions. If you have really a burning desire to ask something, get it to one of the young lawyers right away, and we'll see if we can sneak you in here on the tail end of things. This next one is for Judge Kennedy. And this is probably you probably all have some experience with this. Do you ever disagree with the finding of the jury? What do you do, and what criteria do you use?
Again, that's pretty well prescribed by law. I could tell you in most of my jury cases, I don't really try to come up with if I were on the jury, would it be guilty, would it be not guilty? And one reason I don't is I'm one set of ears that's listening to the facts, that's listening to the witnesses. And what I view as really helpful with the jury system is you have 12 sets of ears and eyes that are watching the witnesses, they watch the demeanor of the witnesses, they listen to things. I know before I became a judge, I would sit as an arbitrator on occasion, and there would be 3 of us. And it's also why the law says, and what we instruct the jury is, don't make your decision until you've heard all the evidence, all the facts, all the law, and you start your deliberations. Because when I served as an arbitrator, I'd go back and I'd sit with my fellow arbitrators, and we would start talking about the case, and they would hear things that I didn't hear. Or I might have heard something that they didn't hear. Or they might have seen something that I didn't see, or seen something differently. And it's really a collective judgment. So I really respect the juror's decision. I've had one case, I've been a judge now for a little over 14 years. I've had one case where I felt that I had to reverse the jury's verdict. I just felt that based on the law and the facts that came out, the undisputed facts, that the jury verdict was not correct. And in that case, I did reverse the verdict of the jury. It was a medical malpractice case. My decision was appealed to the Superior Court, and Superior Court affirmed my decision, meaning they agreed with me. And ultimately, those parties ended up settling the case when it came back to York County. But essentially, unless the verdict is so against the law and the weight of the evidence, the judge really can't reverse that verdict. It almost has to be something, the term that's generally used is something that shocks the conscience. And in the case that I reversed the jury's verdict, I was shocked by the jury's verdict, as were all the court personnel that were in the courtroom. So again, it's I I very rarely disagree with a jury's verdict, and if I would, I wouldn't question it again because I'm one set of eyes and ears, and it's 1 versus 12.
Judge Wren, you'd like to follow?
Yeah, you have to keep in mind when we're trying jury cases, a lot of times we're not up there exactly paying attention to the evidence coming in, and that's because there's so many other things that we're doing. There may be a legal issue that we're researching using the technology in the courtroom that gives us access to Westlaw. We may be operating whatever other technology there is for the attorneys to present their case, the audio-visual stuff. We have to prepare our jury instructions throughout the course of the trial, depending on what evidence comes in. So, half of us might be listening to, what the testimony is, and the other half doing something else, whereas the jurors are focused on what's going on in the testimony and in the trial. So, for us to say, well, we don't necessarily agree with what the jury did, it's probably not an accurate assessment of what we've done or what we've heard.
I'd just like to add to that, because I will tell you, ladies and gentlemen, I am very much surprised at how often the jury is right. Rarely, if ever, do I disagree with what the jury has done. And I tell you, that is because I think we explain to the jurors what an important job they have. The most important job in our judicial system is to sit as a juror. And I tell the jurors when we're getting ready for a case, there are things I don't agree with on the law. For example, I don't agree with the law in Pennsylvania that jurors cannot take notes. They can take notes during the trial, but they can't take notes when the judges tell them what the law is. Well, I think that's ridiculous. I mean, I guess our Supreme Court in their infinite wisdom has decided that I shouldn't be making that decision. And I explain to jurors, I don't agree with that. But I have taken an oath, as they have, to follow the law, and they do that. And jurors work so very, very hard to apply the law and to find the facts. I am overwhelmed at times. We go out and after the trial is over, the jury's liberated, saying, well, boy, I mean, this is such a sad case, one way or the other, that the jury is going to find for this person or for that person because of the sympathy that are involved in these cases, and we tell them that they can't do that. And I tell you, by golly, they come back, they don't do that. They set that aside. I've seen juries where the jurors across the board are in tears because they're entering a decision that they don't want to enter. But they've struggled so hard, and they do such a great job. It's such a very important fact. This is, I tell you something that Judge Wren frequently says, and I tell my jurors. In the jury system, we have 3 branches of government. We have the executive and the legislative and the judicial. We elect governors and presidents, and we representatives and senators, and they go off, and the executives make their decision, the representatives make their decision. It is only in the judicial system where citizens, where you folks right here, when you're called to serve on a jury, when there are 12 citizens tried and true that sit over there in that jury box and make the decision, not the judge, not the lawyers, not anyone else. It is the citizens, and it's the only place in our government where that happens. And that's in the jury system. That's part of the justice system. Jurors do a great job, and rarely do they make the mistakes.
Sort of along these lines, and I'm not sure which judge would like to handle this, but if anybody out here, let's say, unfortunately, okay, I'll use myself for an example so nobody feels bad, but I'm driving home tonight, I run over somebody, I didn't mean to. Let's say I've got to be on the 11 o'clock news, so I keep going. I need an attorney, obviously, whether I broke a leg or killed somebody or whatever the situation is. We all know you can hire attorneys for hundreds of dollars an hour, and some of them are free. Do you notice from your vantage point, do people really get what they pay for? Like, if you get into trouble, is that attorney who makes a ton of money going to get you off? Or do a better job than the other?
I can tell you, there was a probation officer in the county, this was several years ago, that did a study for a graduate course as to how criminal defendants fared being represented by our public defender's office versus criminal defendants who hired private defense lawyers. Mm-hmm. And, You know, we do see the gamut in private defense lawyers. The case that where I described who was, I had to
The
declare the
medical
defendant
malpractice.
incompetent. No, where the drug case where the defense lawyer is incompetent. That was a privately paid attorney. But the study showed that the people that were represented by our York County Public Defender's Office fared much better than the folks that were represented by the private defense lawyers. Now, I know Judge Ness was a private defense lawyer and did a wonderful job, as did Judge Wren. I did some time as a private defense lawyer. I'm not sure if Judge Bortner did. A lot of the judges did do work as defense lawyers. So that, you know, that's all I'll say. I think my advice on getting a criminal defense lawyer would be the same as any other type of lawyer. I wouldn't hire a lawyer based on what I see by an advertisement. I might call around people who are in the system, talk to stenographers, talk to maybe police officers, talk to maybe, you know, people who would know who's good at what they do, and you know, go by word of mouth and reputation, and you know, interview a couple before you decide who you're going to hire.
Because, you know, it's always the stereotype that the poor guy who couldn't afford the attorney, even if he didn't do it, he might accidentally end up in jail, as opposed to somebody who's maybe very guilty but can afford the best might get off. That's the stereotype.
It's not borne out in the real world.
Okay. Again, NBC's Law and Order. I'm watching too much of it, apparently.
One thing I'd add to that is, no matter how good the lawyer is, you can't change the facts. And, you know, I hear a lot of people say they hired so-and-so, and they got this result. They hired somebody else, got a different result. And really what I say is, well, you know, what were the facts of the case? Because I think that's probably going to have a lot more to do with the outcome than who the lawyer was. We have public defenders that do a terrific job. They have lots of cases. They're in court probably more often than many of the private defense bar, and they do a great job.
Thank you. And I'm too honest. I'd probably tell you I ran over the guy, so I wouldn't need an attorney. I'm not sure. This is not directed. Well, Judge Bortner, I guess, could take this one. This is a good question. Can I represent myself in court?
You can. You have a right to represent yourself, just as in a criminal case you have the right to have a lawyer. So you can proceed what we call, what the law refers to as pro se. I do my best to discourage people from doing that, not because I'm trying to create business for the bar. I think that generally you will do better with a lawyer who understands the law, understands the procedures, has been down the road before, and is going to be able to advise you. Another aspect of that, I think, is not just is the lawyer better informed on the law. You know, when you're representing yourself, you get very caught up in the facts of your case. And you need somebody who can just step back and give you some independent advice and objective advice, and sometimes talk to the client like a Dutch uncle and tell them this is what's going on here, and you know, you better realize, you know, where you're headed. When you're representing yourself, you get emotional. We all know you don't make the best decisions under those circumstances. So the answer to the question is you can proceed pro se. I wouldn't advise it. I told somebody one time you can do your own brain surgery, but I wouldn't advise that either.
Right.
The other thing is you need to know the rules of the game. You're expected, whether you're represented by counsel or whether you're pro se, to follow the rules, and you don't get a special break because you don't have a lawyer sitting next to you. So it's a good advice that Judge Bortner gives to, if you can get a lawyer, have a lawyer there that at least knows the rules of the game and the playing field, so you're not there by yourself.
And also to pick up on what Judge Bortner said, when I was handling criminal cases and somebody said they wanted to represent themselves, we all, I think as criminal judges, conduct an extensive colloquy with that defendant. We go through very carefully, try to explain the elements of the crime. We try to explain their possible suppression motions that could be considered, other types of motions, how you pick a jury, and that's something we don't do for the self-represented litigant. And they just, as has been mentioned, they get so emotionally involved with their case, they forget to follow through with what I've tried to explain to them during that colloquy. Fortunately, after I've gone through a colloquy that's pretty extensive with them about representing themselves, they usually do go down to the public defender's office or go seek private counsel.
And a colloquy is?
Is basically a full discussion with the individual to assure that he or she understands the process, understands various motions that could be filed upon review, understanding going through the discovery phase of what you're looking for, how to, I can't tell them how to read an affidavit, but a lot of times an attorney will be looking at all of this on behalf of the defendant and be able to pick up nuances that that self-represented person would not be able to do.
Thank you. This last question, and I'm sorry if yours didn't get answered, but we apparently cannot stay all night. Judge Linebaugh, and this is a follow-up to something that was said before. Interesting. If all the facts of a trial are reviewed before trial, presented in trial, briefs and purposed finding of fact, what is the purpose of a trial?
Well,
brings the mic over slowly.
If you are, why do I keep looking for an easier question? If you're talking about a non-jury trial, I will be very honest with you. There really is not any good purpose for doing that in many cases, and it is not unusual for me to have a pretrial conference, and maybe we've had a whole series of conferences, and it's not unusual for the lawyers to say to me, you know what, Judge, we have now come up with our stipulated facts, and they may have 10 pages of stipulated facts, and they've looked at it and said, well, what else is there for you to produce for me? And they said, well, there really isn't anything else. And they agree that it would be submitted to me based on their legal arguments and on the stipulated facts. I think the reason why that they do want, in some of these cases, go on and have that trial. Now, there are some times when there are some disputes about certain things. I'm thinking frequently if there's disputes involving land and property boundaries and that type of thing, where we have a trial and I go out and take a view of the property. I do that quite often in non-jury trials. I'll go out and view something, the disputed land, the disputed property line, or something along those lines. But quite frankly, I think it's because they have a difficult time coming back and explaining to their clients all the facts are before the court, and you're not going to get your day in court. People want to have their day in court. They want to come in, they want to sit in the stand, and they want to tell the judge their story. They want to be able to get their story out, and they want to be able to do that. And I think that's a lot of it. And there's something to be said for that. There's something. Now, I will frequently stop people, or the lawyers will be objecting, and they want to get into something. They want to tell me how bad that other person is, because if I hear what they did to their cat or their dog or something along those lines, then I'll understand that this is a bad person. Well, that's not admissible in the court of law, and the lawyers are object, or we stop them and hear them from that. But they want to get in, and they want to have their day in court. But there's a lot of what I do that is so fact-driven. We're not disputing that. We don't need to see the witnesses testify to judge their credibility as they do in criminal trials or civil jury trials, where the jury has to judge your credibility, because there's no issue. They've already produced all their facts. And I would say that on the non-jury trial, 70% or more of those cases could be done just on a stipulation of fact, because there is no dispute of fact.
Thank you. Actually, go ahead.
Even on jury trials, I think the average person watching a jury trial would be surprised at the amount of facts that are not in dispute. Very frequently, we'll get jury trials, for instance, in a car accident, where one side is admitting total fault, which means really technically you wouldn't have to say anything about how the accident happened, just how the person was injured. But they go into the evidence as to how the accident happened, so the jury gets a better picture of how the person was injured. So even though those facts may not be in dispute, and the attorneys may not even argue to the jury who was negligent because that issue's already been resolved, there are still one or two other issues that you do need facts on. But many times in jury trials, there are a lot of things that just simply aren't in dispute.
And actually, I'd like to go ahead and pose one last question to, we'll go ahead and give it to our President Judge, Richard Wren, because this is something that could affect anybody here. What factors do attorneys consider when picking a juror?
Well, 12, 14 years ago when I was doing that, a lot of it depended on the type of case. You know, there are many jury studies out. Certain demographics are more inclined to think, you know, one thing about a certain case than another. So you always have those in the back of your head. But when you're looking at jury selection, you know, it can be anything from the way the juror looks at you or looks at the client. You have to talk to your client, so if they say, you know, I didn't like the way that person looked, okay. A person's occupation may affect whether or not I want that person on the jury. And I know I'm being general, but again, it's so case-specific that it's really difficult to make any generalizations that would stick. In selecting a jury, you're entitled to a certain amount of what we call peremptory challenges. And again, it depends on, in criminal cases, the nature of the offense. Civil cases, you're basically allowed 4 per party. Those challenges are simply that you can take a juror off for no reason. So attorneys can, again, use any of the factors based on whatever perceived jury studies they have. Occasionally they'll have an expert in the courtroom advising them on body language, occupation, family background, you know, anything like that. Other more specific reasons are what we call for cause. If a juror has expressed a fixed bias toward a particular issue in the case, that would be grounds for excluding that juror for cause, and the attorney could ask the judge to excuse the juror for that particular reason. Bias against one of the parties. More likelihood in a criminal case to believe a police officer than anyone else who would testify. Those types of things can be used either for cause, challenges for cause, or one of the attorney's freebies, if you will, the peremptory challenge. But to generalize, it would be hazardous, again, because it really depends on the type of case you're talking about.
Okay, great. I'd like a warm round of applause for the judges who gave up their time. And they may want to join in for the great questions that you asked and your community involvement. So thank you so much. You know what? I'm going to just reintroduce Dean Dominic, the president of the York County Bar Association, and he can address that. But in the meantime, thank you all for being here. I'm really impressed that you had a showing of this many people. I wish it was going to be on Channel 8 tonight, but I'll have to talk about it before the weatherman or something. Thank you very much for being here.
Thank you.
I just again wanted to thank the members of the bench for taking time out of their schedules to come here this evening, for Janelle for moderating this for us, and good luck to your sister and your impending aunthood. And most of all, to thank you, the public, for being here tonight and making this event a success. To answer your question, we don't have anything scheduled at this time. Frankly, we weren't very sure about how well this was going to be attended tonight, and seeing how well it was, we'll certainly consider doing another event in the future. And if we do, the questions that were not answered this evening will be the first ones around. Thank you again. Have a good night.